Hi, good day. A very warm welcome if you are a first listener, and for those that have listened to my two previous training videos, welcome back. We are discussing the Protection of Personal Information Act, Act number 2013, PoPIA, or more known as PoPI. Now, this three-part training video series, this video is for the employee and employee training and their right to know what has been kept, why it is being kept, and what is their duties and rights in terms of personal protection of personal information, presented by myself, J.A.P. Kokemoer, representing J.A.P. Kokemoer and Associates, and this is for all your compliance requirements. Again, thank you for listening, and let's dig into this training. The presentation overview, we're going to be looking at the background of the Act, the personal privacy protection and your rights, your personal information covered, special personal information that is covered by an organization, and duties of employees in terms of the Act. Now, first and foremost, what is the purpose of PoPI, personal information and the protection thereof? The introduction of PoPI records that PoPI emanates from Section 14 of the Constitution of the Republic of South Africa, 1996, which section provides that everyone has the right to privacy, and it includes a right to protection against the unlawful collection or retention, dissemination, and the use of your personal information. PoPI also gives expression to the constitutional values of democracy and openness, recognizing the need for economic and social progress within the framework of the information society and the need for and removal of unnecessary impediments to the free flow of information, including your personal information. PoPI has been promulgated to regulate in harmony with international standards. So if you look at Europe, you look at USA, you look at UK, this is long overdue in terms of protection of personal information. The processing of personal information by public and private bodies in a manner that gives effect to the right to privacy subjects to justifiable limitations that are aimed at protecting other rights and important interests of a data subject, and we'll talk about a data subject. Does PoPI apply to employers and their employees? This hails a new dispensation for employers and employees. It introduces obligations on employers and grants rights to employees, your right as an employee, in an attempt to balance the right of employers to conduct business with the right to privacy of its employees. So I can't just gather information and dish it out. There's certain rights and duties to the employers. PoPI is not limited to the parties to an employment relationship, but there is no doubt that they are subject to its protection because there's a relationship contract between you and your employer, and that is called the contract of employment or your employment letter to employment. What is a data subject? Who are they within an employment context? PoPI refers to the person to whom personal information relates as data subjects. Within an employment context, this includes applicants and former job applicants, successful or unsuccessful, former or current employees, temporary employment service staff, casual staff, staff on secondment, and those on work experience placements like learnerships, internships, etc. The personal information of all of these persons must be dealt with in accordance with PoPI, Personal Protection of Personal Information. Your personal privacy and protection. Data subjects have the right to, so you as an employee have the right to access your personal data, and that is kept by the employer. Correct errors on your personal data, and you are urged to really make sure that your personal data kept by your employer are up to date. So if there's a change in address, there's a change in dependents, certain data required by your employer, that needs to be updated on a regular basis and on an as and when basis. You can also ask or your employer to erase your personal data. At the end of the day, that means that the employment relationship has been terminated, and that's been the reason for erasing your personal data. Object to processing of their personal information. So in the event of a question comes from a third party for having access to your personal information, you can object to that request in terms of having access to your personal information. Justifications for processing of personal information. So what is justifiable? Permissible grounds on which personal information is allowed to be processed are. Remember, you can object, but this is grounds on which personal information is allowed to be processed. If you give consent by the employee, so you've signed a document that is addendum to your contract of employment, and you have given consent to your employer to deal with your personal information. The processing is necessary for contract to which the employee is parties. For instance, your employment contract, maybe medical aid, maybe provident fund, maybe revenue services. There's a legal obligation to perform processing, for instance, revenue services for pay-as-you-earn purposes, and then protection of a legitimate interest of the employee. So in the event of protecting you, that is a legitimate reason in terms of handing out your personal information. Public law duty by a public body in the event of a court order or you being summoned to testify as a witness, and then necessary to pursue the legitimate interests of the employer by a third party, which means it could also be the police or the courts that is requesting personal information. So this is permissible grounds in which the employer can deal with your personal information. Okay, to my audience, what manifestation of information are covered by the PoPIA Act? It applies to any personal information entered into any record by any employer, whether it's your ID, whether it's access control at the gate, whether it is for payroll purposes, any information gathered. A record includes any writing on any material, labels, books, maps, plans, graphs, drawings, photographs, films, negatives, tapes, or other devices where visual images are stored. So also in the event of your fingerprint where you have to sign in at the gate in terms of biometrics, that is also seen as personal information. Personal information about individuals that is kept by an employer on a computerized system, maybe cloud-based, maybe on a server, in the employment context falls within the scope of PoPIA, subject to limited expectations. So whether I keep your personal information manually or whether I keep it electronically, that is seen as information kept by the employer. What employment-related information is protected in terms of PoPIA? PoPIA covers all information that employers might collect or retain or archive on any individual who might wish to work, so even job seekers, or have worked for the employer. This includes both personal and special information, and we'll be looking at special information. What is personal information then? Personal information is information which is about a living identifiable person. So obviously you and me, a data subject, and affects that person's privacy, whether in his, her personal or family life, business or professional capacity, in the sense that the information has the person as its focus or is otherwise biographical in nature and identifies a person, as I said, your fingerprints, photo, surveillance, whether by itself or together with other information in the organization's processing, or that it's likely to come into the possession of the company or of the responsible person or of any other third party. So yes, let's then look at what is your special information kept or possibly kept by the responsible party, the employer. Special personal information is information concerning an individual's religious or philosophical beliefs, race, ethnic origin, trade union membership, political persuasion, health, your sex life, biometric information, criminal behavior, so I can't go and just do a criminal check without your consent of a person, subject to the extent that such information relates to the alleged commission by the employee of any offences or any proceedings in respect of any offences allegedly committed by an employee, or about the disposal of such proceedings. So let's take the example, you have been maybe dismissed at your previous employer. Your previous employer may not disclose this information in the event of asked by a third party, which possibly could be the new employee which you have made an application to. So anything that pertains to you as a person is supposed to be protected under special personal information. Further to that, special personal information processed by an employer might typically be about an employee's physical or mental health as part of medical records. So in the event of the medical aid wants to know about your medical health, that is also personal information, and without your consent, the employer is not allowed to give it out. Records obtained as part of a pre-employment medical questionnaire or examination, various drug or alcohol tests, and the results, sick leave records, pre-employment screening, records relating to criminal convictions, and any aspects of special personal information may not be disclosed unless consent has been given by this data subject, which is you, the employee. Personal information covered by PoPIA includes details of an employee's salary, bank account, email, any incidents, a supervisor's notebook in the event of supervisor keeping notes or there's a possible performance appraisal being done. That is also personal information. An individual's employee's personal file, your leave records, performance reviews, a set of leave cards depending upon how they are kept, and a set of completed application forms filled in particular order. So as and when you do apply for a particular position, normally there's an application form. All that info on the application form is seen as personal information, because on the form normally they will ask for a next of kin, a personal detail, and that is also protected and is not supposed to be disclosed in terms of the application form. So it goes beyond just the one data subject. It goes coincide with any information that is gathered on an application form. Okay, so then when can we process your special personal information? And it's prohibited unless, remember, special information is anything that's got to do with your gender, your age, your religious belief, any criminal record, any dismissals, anything that is linked to a subject or a data subject. We can process the special information if you have given consent. Again, the information has deliberately been made public by the employee. So for instance, you are notifying your employer that you've got a disablement, which the employer might not have known. That is special personal information that you've actually made public by yourself as a data subject. The processing is necessary for establishment, the exercise or defense of a right or obligation in law. So in the event of court order that can be processed, the processing is necessary to comply with an obligation of international public law. So for instance, you might travel overseas, and there's special information about the data subject, and before you can travel overseas, it is required by the international law to have that special personal information. The processing is for historical, statistical, academic or scientific research. So for instance, Stats SA comes around, we are doing census, and obviously they are gathering information about special personal information. Then the regulator has granted an authority for the processing in the public interest, and there are appropriate security safeguards in place. Again, the emphasis, appropriate security safeguard, but the regulator has issued a compliance to grant authority in terms of processing your special personal information. It is in accordance with the specific circumstance prescribed by PoPIA. So on the end of the day, we need to know the content, and that will normally be handled within your privacy and security policy, and you also have to familiarize yourself with the policy of the company in terms of privacy and security, so that you can know what is the special circumstances or specific circumstances in which special personal information can be processed. So when information is being collected, data subjects, employee must be made aware of in terms of Section 18 of the PoPIA Act, the information that is being collected, and if the information is not being collected from the subject, hence the subject must be made aware of the source from which the information is being collected. For instance, you have applied through a recruitment agency. That recruitment agency has provided your information to the former employer. So I need to make you aware of where I got the information from, meaning the name and the address of the person or organization collecting the information, the purpose of the collection of the information, whether the supply of the information by the subject is voluntary or then mandatory in the event of you need to register as a taxpayer. The consequences of failing to provide the information, whether the information is being collected in accordance with any law. So what could the consequences possibly be if I'm not notifying the data subject? When information is being collected, subjects must be made aware of, again, Section 18 of the PoPIA Act, if it is intended for the information to leave the country, and what level of protection will be afforded to the information after it has left South Africa. So in the event of your holding company might be in the UK or somewhere in Europe, and we need to transfer your information to the centralized databases because HR is sitting in Europe, how are these or how are the company going to make sure that if your information leaves South Africa, how is it going to be protected overseas? Who will be receiving the information? So it's important to notify that it's going to be HR or it's going to be head office, or whatever case the reason might be, that the subject has access to the information and the right to rectify any details. So again, making sure that any detail upon a data subject is correct and it's quality information. That the subject has the right to object to information being processed if such rights exists. On the end of the day, again, I'm referring to your privacy and security policy. In that policy document, it will state when and when not information would be processed in the event of a data subject. That the subject has the right to lodge a complaint to the information regulator. So again, I just want to make sure that you understand in terms of your policy and procedure that you first have to exhaust all your internal procedures and processes before you actually lodge a complaint to the information regulator, giving the employer a fair chance to rectify any unnecessary breaches. Also in your policy document, the contact detail of the information regulator will be supplied in the event of you want to lodge a complaint towards the information regulator because of a breach of your personal information. What is the areas then affected by PoPIA Act? First and foremost, again, the employer, employment recruitment agency will collect your data for processing purposes. That data then will be stored either manually or electronically. It will also be then retrieved in the sense that it's now need to be processed, to be used by then the responsible party or responsible parties, and making sure that also in the event of collection, the storing, the retrieving, the usage, that there's no data breach in terms of your personal information. So I'm not leaving my computer open, I'm not leaving your application form lying around at printers or unnecessary places where it's unauthorized for people to look at. So I, as the responsible party, need to make sure at all times that any information which is on paper or electronically is protected. And then how do I retain your information? Where do I keep? Where do I make sure that it's safe? And lastly, how do I get rid of your personal information as and when the employment-employee relationship comes to an end? And by what means do I make sure that your personal information till end of distraction is protected? So in essence, we must make sure as responsible parties that we go the full circle, making sure that your personal information is protected at all times. Now let's look at some of your duties as an employee. You need to follow company protocol at all times. As said in my previous video, it's business as usual. It's a way of life. It's a way of living. It's a business culture to protect your information, to protect the company's information, and to protect your fellow employees' information. And that should take precedent above anything. So following company protocol at all times. Then familiarize yourself with the company privacy and security policy and procedures, making sure that you understand what is seen as privacy, what type of information is gathered, for how long it's going to be kept, and obviously in the event of a breach, what is the internal procedures to be followed if you feel aggrieved that your personal information has been breached. And further, familiarize yourself with the PoPIA manual, the personal access to personal information, and how you can gain access to your personal information, and also possibly by a third party, which we mentioned in terms of possibly the medical aid or insurer or South African Revenue Services, any third party that might require or acquire your personal information. You need to follow internal company procedures. As said, don't just jump the gun. Follow internal company procedures, exhaust company procedures before you take it any further. Then protect your personal information. First and foremost, your information. You don't want identity theft. Those of your fellow employees, so you're not allowed to give out any personal information of any fellow employee or discuss anything that is personal pertaining other fellow employees. For instance, one of your fellow employees got a bad performance review, it got to your ears, and now you're discussing it with another employee, which is not allowable. You cannot disclose and discuss any personal information with a fellow employee about another employee. And lastly, those of the company. You're also there to protect company information, because ultimately, on the end of the day, that's your bread and butter, and you need to protect them as well. And not to disclose information when it is inappropriate. On the end of the day, you get a telephone call, you might be working as an HR administrator, somebody doing a reference in terms of a former employee. You are not allowed to disclose any information about the former employee. So that is when it's inappropriate. And become a role model. Become a role model employee. Become a role model citizen. As said, business as usual, it becomes a way of living. It becomes a corporate culture of how we do things around here in terms of protecting personal information. So again, the urges, you, the role model, and the role model employee of the organization. In my conclusion then, protection of personal information isn't a choice. It is law, and you, me, the next person, we are all affected by it. And if you look at the PoPIA Act, there's heavy penalty fines, there's possible imprisonment. So on the end of the day, it's for you and taking ownership as an employee to protect first and foremost your own personal information, as well as those of your fellow employees and those of the company. With that, I'm pretty sure there might be certain questions. You can address those questions to cars@businesscompliance.co.za. I will revert back with an answer, possibly make an appointment with a company to come and address issues. So please revert all questions to the following email address. On that note, I would like to say thank you for listening. Thank you for your time. Thank you. And again, protect what is yours. Protect what is your fellow employees. Again, my name is J.A.P. Kukamur, representing J.A.P. Kukamur and Associates, at your service for any of your business compliance. Please ensure, ladies, gents, my audience, that you have signed the attendance register. We as employees, as responsible parties, needs to provide proof that all employees have been trained in terms of the PoPIA Act. So do make sure that you sign the attendance register, and again giving your consent and that we can use your information in terms as and when required by the regulator, that we have trained you in terms of the compliance aspects of PoPIA.